A recent change to the corroboration rules for sexual offence cases means there no longer needs to be evidence from two separate sources that sexual penetration took place. Instead, distress in the immediate aftermath of an incident seen by a third party can corroborate a rape allegation. A campaigner who fought for the reform after her own case was dropped says she's been told that under the new rules there would now be sufficient evidence to bring her abuser to court. Emma Bryson has been talking to STV's senior reporter Gordon Cree.
When we spoke 7 years ago, it was at the start of a major campaign to have corroboration in these cases scrapped.
Yeah.
Down the years, there have been various developments on that. Do you feel that where we are now has been a success from what you envisaged back then?
Absolutely. I think over the course of our campaign, I think initially we'd set out with the view that corroboration needs to be abolished, but I think as we learnt more about it and engaged, we engaged with politicians, we engaged with the legal community and, kind of other organisations as well, what we came to understand was that it needs to be reformed to enable more cases to be taken forward. So, and that was very much what we've been promoting. I think in terms of what the Lord Advocate has succeeded with her references has effectively achieved that. It has reformed corroboration in exactly the way that it needed to be reformed to allow more victims of sexual offences to now see their cases being taken forward.
What difference would this have made in your case?
I've been told that in my case that the evidence available would now be considered sufficient to meet the new requirements for corroboration. And the key elements for that are that members of my family were aware of what happened at the time that it happened. So that was, at that time they had seen evidence of my distress. They were aware of what had happened. It was never really a secret. I did talk about what had happened to me, and it was common knowledge within the family because other members of the family were also had the same experience that I did. So at the time that I reported in 2016, none of that could be considered as evidence. But now, if there are witnesses who were aware of what happened at the time that it happened, or who are aware of the distress or changes in your behaviour, so distress doesn't necessarily mean that you were emotional and crying. It could be things like a change in your behaviour. You might have been withdrawing. You might have suffered depression. So, and again, sort of within a kind of a certain time frame of the event, that is now the key difference that's changed.
Unfortunately, in your case, the perpetrator has since died.
Yeah.
Do you feel cheated by the way this has played out?
If I'm honest, my first response was relief. When I was told that he died, I was relieved because it meant that he couldn't ever hurt any more children. And that was really, really important to me. On a personal level, of course, I was disappointed. It has taken me some time to come to terms with that. But I think ultimately, I know that the work that we've done, that Susie and I have done, and along with Shirley, kind of in the early days of the campaign as well, has enabled the Lord Advocate to take forward these references, and we have been credited by her for that. And so I know that despite my personal disappointment, I know that the work that I've done over the last 7 years has made a material difference to other people like me who now have a much better chance, in fact a better chance than ever before, of seeing their cases taken forward. That means a lot to me.
There will be women out there who have previously been told by the police when they've reported things that there was no prospect of a prosecution. What should someone who is in that situation do now? So
if you have previously reported a sexual offence and you were told that it couldn't be taken forward because there wasn't sufficient corroboration, the key element is that sufficiency of corroboration is specifically around people being aware of what happened when it happened and being aware of the distress of the victim. So there needs to be statements provided. So I was lucky in my case that members of my family were prepared to give statements to that effect. It's not the case that if you were told that corroboration wasn't available, that you can go forward now and expect that your case will be taken forward unless those two elements have been met. So that people being aware of what happened when it happened and being aware of the distress of the victim, basically.
But you're confident there'll be a reasonable number of people in that situation?
I would think so. I mean, I'm sure there are people like me who did report what happened. I mean, I reported the first time when I was 14 years old and nothing happened, and I went back to the police again in 2016. There will be people who have reported it previously. There will be people who, whose family members or partners or friends were aware of something that happened, and I would say that there is a good chance. So I think anyone in that position who might wish to have their cases reviewed, I think in the first instance should make contact with their local Procurator Fiscal's office and take advice from there.
You've put a lot of time and effort into sort of seeing this campaign through. If this makes a difference for one person who gets a prosecution they wouldn't otherwise have done, that makes it all worthwhile, doesn't it?
Absolutely. 100%. Absolutely. I wouldn't want anybody to have had the experience that I had, that sense of the injustice of it, the knowing that, that something terrible had happened, that other people were willing to come forward and speak on your behalf, and imagining that that there was a chance of achieving justice, and then be told no, there wasn't a possibility of achieving justice. And that was because of the way that the requirements of corroboration effectively protected sex offenders. This has dramatically improved, and I would encourage anybody, if you haven't reported before, I would encourage you to come forward now. Your chances are much better. And if you have reported previously and you think that the evidence in your case might, meet those requirements around the time and evidence of distress, then absolutely it is. I would encourage anybody to come forward.
Emma, thank you very much for talking to us on Scotland Tonight.
Emma Bryson there talking to Gordon Cree. Well, with us now, the defence advocate Thomas Ross. Thanks so much indeed for joining us. We heard there how very positive Emma Bryson is about the changes to the corroboration rules which she campaigned for. It's not a change that you wanted. I mean, what were your concerns?
Well, my concerns were simply that corroboration provides one of the main safeguards against false accusations. I should say that I met Emma at this studio many years ago, and I immediately formed the view that if everybody was as straightforward and credible as she was, then we wouldn't need corroboration. But sadly, that's not the situation. We still have cases in court where people are convicted of false allegations, not a lot of cases. But corroboration applied rigorously can protect against that, and once you start to pretend that things that clearly are not corroboration are corroboration, then you can get into difficulty. I
mean, is there any evidence that there are any, an increased number of cases where there's false allegations?
No, I mean, I don't think there will be many false allegations, but the fact that they're few in number, I suppose, is very scant consolation if you're in prison in relation to a conviction which followed on from a false allegation. I mean, I don't think it would give you much comfort that there's a low percentage of them. If you've been put in the sex offenders register, taken away from your family and locked up in a cell 23 hours a day.
Rape Crisis Scotland have said that claims, the false allegations are common, are not supported by research, and this idea that there are a lot of false allegations or false allegations is very harmful to survivors, for whom the decision to disclose or to report to the police can be agonising, because it is a difficult process, isn't it?
I'm not here to debate it. It's absolutely beyond debate. People are convicted in court in relation to making false allegations, and through their lawyers they present pleas in mitigation explaining to the sheriffs why they made false allegations. These examples can be found in a simple Google search, and you'll find cases all over Scotland where people have been convicted of it. So I don't care what Rape Crisis say. The reality of the situation is that people have been prosecuted in relation to making false allegations.
Campaigners had hoped that this change would lead to more cases coming to court. I know that the law, the change is in its early days. Have there been more prosecutions?
I think it's estimated in the High Court where I work, about 75 to 80% of the cases in the High Court are sex cases. And so most days, most of the courts are dealing with sex cases. So against that background, it's very hard for us to know. I mean, there may be statistics in relation to it, but the impression you get when you're there is that most of the lawyers, most of the prosecutors and most of the judges are dealing with sex cases every day of the week.
That seems extraordinary that it dominates proceedings.
Well, that's the facts of the matter. So, you know, which is a good thing. You know, if the right people are being convicted and brought to justice, I'm firmly in favour of that. So I don't have any difficulty with it.
And very briefly, do you think there are more cases now because it's retrospective and people are coming forward with older cases?
Yeah, I mean, there are a lot of older cases. I'm not sure that it's due to the change in the law of corroboration. It might just be that they realise that older cases are being taken seriously.
Okay, we'll have to leave it there. Thomas, thank you.